stay out of Illinois for now. Welcome to Law and Society, and I'm going to do a sort of a summary of what happened in court. Judge Sarah Ellis for the Northern District of Illinois, Eastern Division, has granted a temporary restraining order that applies to all federal agents in the Northern District of Illinois. So this is different from how Oregon and California approached it. Mind you, the court there, Judge Immergut, stayed the deployment of guard into Oregon. Okay. She also ordered stopping the federalization of the guard, but that part of the order was stayed by the Ninth Circuit Court of Appeals. But the order that all National Guardsmen need to stay out of Portland and that district, that judicial district, is still in effect for probably another 10 days or so, and then there's going to be disposition on it. But that is not how Illinois has gone about it. The complaint was against the federal agencies' ICE raids and the assault on Illinois and Chicago, in Chicagoland, of the federal agents. In fact, there's no reference at all to the National Guard deployments of Texas or Illinois. So that's an entirely different sort of legal claim, which I believe that Illinois is keeping in their basket for now, instead of putting that as an argument. Because, that's just my thought, it's because if you order federal agents of the Northern District of Illinois to essentially stop doing what they're doing and follow the law in doing what they're doing, which is what Judge Sarah Ellis says, it actually frustrates the purpose of the National Guard being there to begin with, because they were there to get in between the federal agents and the people. So the federal agents are enjoined from doing the things that they were doing in Chicagoland, and that'll include all the things that are in the complaint. It includes pepper spray, tear gas, all of those things, hitting people with rubber bullets. All of those things are enjoined temporarily for 14 days. And pending litigation. This is just a temporary restraining order. It's a preliminary thing. It's not even a preliminary injunction on. The court is giving great deference to the executive branch by even saying in her order that this order applies to all the defendants except for Donald Trump. So if Donald Trump wants to physically come and do all of those things, he's able to do it. But federal agents are barred. I mean, it's kind of an interesting thing, because in the very first page, in the first footnote, the court holds that President Trump, one of the named defendants, is not included in this order. So I found that to be interesting. But what I'm going to do now, we're at a 4-minute mark. If you have had your full of sort of the summary, that's where it ends. It doesn't talk about the National Guard deployments. It talks about federal agency actions being taken that are causing harm in the Northern District of Illinois. And Judge Sarah Ellis puts a temporary restraining order on the conduct that has been alleged in the complaint. Because, as the procedure would go, it's the judge has decided that it's more likely than not that this would, rule in favor of Illinois as opposed to the federal regime. And so what I'm going to do now is I'm going to go through just a few parts of the complaint and give you a sort of a context of where this applies and what the national federal agencies under Donald's regime are doing or were doing and are enjoined to do right now. So, the state of Illinois, the cases by Chicago and the state of Illinois and the newspaper guild and there's the Chicago Headline Club, and so this is a case that is perhaps joined by the government, but it's not one of the named plaintiffs. But there are the Press Association and individual plaintiffs who've been harmed. And we talk about class certification in this suit because they're seeking a class certification of what the type of people who are being targeted and essentially stopping them from behaving in that way. So the complaint alleges that roving patrols of masked, militarized, and often unidentifiable agents have been seen on streets from Chicago's city center to its suburbs. Federal agents have killed civilians and they have used extreme and unlawful force against individuals. They have illegally stopped, detained, incommunicado, and arrested hundreds of people, including many citizens. Federal agents have arrested elected officials without any basis. They have conducted military-style raids on civilian apartment complexes, terrorizing residents, including children, and demolishing personal property. They have blown off the door of people's houses with explosive devices. They have shot at people. They have thrown tear gas canisters on city streets. They have conducted operations at hospitals, schools, and places of worship. Defendants have focused their federal incursion on cities in blue states where defendants make up the majority of the voting constituents, like Chicago and Los Angeles, or blue cities in red states like Memphis and New Orleans. I just have to stop here and say that that's exactly what I warned about. I don't know how many videos ago. And and we're here. And that wasn't very long ago that I was warning about it. Donald Trump has said that such cities pose a war from within. Remember the word war. And I want to keep reminding you about the war because it is coming from Donald Trump. And then when you talk about levying war, as it would be under U.S. law and therefore treasonable, there is an argument there that is very much alive and well. And I would like to see legal experts talk about that. So Donald Trump has said that such cities pose a war from within. He has instructed the Secretary of Defense that we should use some of these dangerous cities as training ground for our military. Trump has specifically said he is deploying federal forces to Chicago against Pritzker. The defendants have focused on journalists and media organizations they do not agree with, repeatedly referring to journalists as disgusting, crooked, dangerous, and most significantly, as the enemy of the American people. Again, enemy, war. Donald Trump has suggested that critical media coverage of his administration is illegal and no longer free speech. Like, that's how far that Donald Trump is going and pushing the limits to see whether it can encroach on our individual rights. Defendants have made clear that they are against protests in general, and that protesters should be met with violence as a consequence of speaking out. For instance, President Trump stated that protesters in the Chicago area were going to be met with equal or greater force that was used in Los Angeles. Defendant Noam, who is a defendant in this lawsuit, added, the more they protest, the harder ICE is going to come after them. Trump has said that in the good old days, protesters were treated very, very rough. And when they protested once, they would not do it again so easily. So you're threatening the American people and getting in the way of First Amendment rights. So, and later on, I'll talk about the complaints that have been brought, the charges of violation of First Amendment, violation of Fourth Amendment, violation of Religious Freedom Acts, violation of having a conspiracy of rights against the people, deprivation of rights. So Secretary Noam has promised the agents stationed at Broadview that they will be given full authority to hammer and arrest the protesters from the way they were talking, the way they were speaking, who they're affiliated with. And that harkens back to the National Security Presidential Memorandum 7, NSPM 7, that I did a video on last week when it was issued. And more people need to talk about it and really discuss it. Defendants have clearly stated that they intend to illegally arrest civilians. The DHS has stated that it is now federal government policy to conduct arrests based on reasonable suspicion rather than the probable cause standard required by the Fourth Amendment. So that's where the violation of the Fourth Amendment comes in. Similarly, another defendant has indicated an intent to use arrests as a means of suppressing free speech by referring to the newly erected free speech zone outside the Broadway ICE facility as the free arrest zone. Governor Pritzker last week said that the Trump administration's rhetoric and operations in Chicago are authoritarianism. And so the complaint goes on in further detail about the Midway Blitz and about federal officers responding brutally to squash dissent and giving examples of that from all around Chicago, and talking about the plaintiffs who were harmed in Broadview. The mayor of Broadview, Katrina Thompson, has made federal agents aware of the harm their actions are causing to her community. Mayor Thompson stated the relentless deployment of tear gas, pepper spray, and mace at the ICE facility is endangering nearby village residents, harming police officers, harming firefighters, and American citizens exercising their First Amendment rights. Broadview Chief of Police echoed these concerns, explaining that federal agents have verbally abused his officers and stating the employment of tear gas, pepper spray, mace, and rubber bullets by ICE is creating a dangerous situation for the community and our first responders. So then he gives instances of where the First Amendment violations happened also in Chicago and against journalism and journalists in Logan Square, Humboldt Park, and Brighton Park neighborhoods of Chicago. On October 3rd, residents of Logan Square spontaneously gathered to express their opposition to the immigration activity occurring in the area. The crowd was peacefully voicing their opposition to the tactics and the mission of ICE officers. ICE officers responded by yelling slurs at the assembled crowd, including calling one protester a faggot, and then, without warning, an ICE officer threw a canister of tear gas at the assembled protesters, thereby violating our rights to peaceably assemble on public property to have our grievances be known. Chicago police officers took up a position between the protesters and the federal officers, but at some point, the federal officers pushed past the local police officers and began pointing weapons at the protesters and used less lethal ammunitions, including flashbang grenades, tear gas, and rubber bullets. In one incident in the neighborhood, a group of 5 or 6 CBP officers shot tear gas canisters without any warning into a group of people who were peacefully protesting 30 to 40 feet away from them. Chicago police officers and civilians alike were subjected to the tear gas and forced to disperse from the streets and sidewalk. I bring that up and talk specifically about it because, now Chicago police officers, state officers, are witness to federal overreach, federal oppression, federal attacks, the weaponization of federal agencies. And they are ready to be witnesses to a lawsuit against the federal government. And that gives the lawsuit a big strength compared to the government or Donald Trump's regime's argument. And we're seeing that in this complaint. There's no indication that federal agents will cease or alter their pattern of use of excessive force against protesters. To the contrary, recent developments suggest that the use of force will be amplified. The memorandum concluded by stating, the Attorney General directed the U.S. Attorney's Office for the Northern District of Illinois to charge all arrested individuals with the highest provable offense available as they were arresting these people and making these unlawful arrests in violation of Fourth Amendment. The memorandum concluded by stating these priorities are directed not only at criminals who are caught red-handed committing acts of violence against ICE facilities and personnel. Now here's the part that goes back to that NSPM 7. But also every person who aids, abets, or conspires to commit these crimes, whether through funding, coordination, planning, or other means. Additionally, Trump has doubled down on his view that squashing protests in cities like Chicago is a war. Again, war. Going back to that levying war thing I've been talking about, that must be won. On September 30th, Trump instructed a gathering of military leaders to use American cities, including Chicago, as a training ground for the military. That's a war too. It's a war from within, Trump said. We're going into Chicago very soon. That's a big city with an incompetent governor. First of all, Brandon Johnson is the mayor of Chicago, and the state is Illinois, of which Governor Pritzker is the governor. Donald Trump's, the way he talks, he can't keep things in order. Big city, incompetent governor, big city not governed by governor directly. Anyway, okay. Trump's repeated statements that Chicago will be used as a site of military intervention, the AG's identification of the Broadview protests as a justification of increased law enforcement presence and consequences at protest sites in Chicago and nationwide, continued threatening commentary from federal officials, in combination with actions of federal officers as described above, have chilled the lawful exercise of plaintiffs' First Amendment rights. This has impacted journalists. On October 2nd, at a purported effort to protect the protesters, the Illinois State Police attempted to establish for the first time First Amendment zones where protesters were entitled to exercise their right of free speech from free from brutality, harassment, and arrest. This did nothing to deter or deflect the ongoing illegal federal conduct as described in the preceding paragraphs, which will recur and continue with even greater ferocity unless enjoined. Speaking to the assembled federal officers and gesturing towards the state police, First Amendment zone defendant Bovino asserted that this is an unsafe crowd and that the area around Broadview ICE facility was going to be a free arrest zone. Noem also stated that today when we leave here, we're going to go hard. We're going to hammer these guys, referring to the protesters. Noem objected to the protesters because of the way they are talking, speaking, who they are affiliated with, who they are funded with. Again, going back to the National Security Presidential Memorandum 7, that goes to call these people domestic terrorists, laying the groundwork for that false pretext. And what they're talking about as far as consequences from what we're doing, she said, we're going to make sure there's consequences for the way they're behaving, and we're going to prosecute them. For what? For free speech? Like, where are you coming from? I mean, coming from her, it makes sense. She doesn't know what the meaning of habeas corpus is. And Donald Trump doesn't either, by the way. None of this is meant to inspire confidence either, by the way. So, going on, Noem emphasized that they would send a message and that defendants were here to stay and expanding. So then the plaintiffs go into the class certification thing and talking about the relief that's being asked. Defendants are violating the plaintiffs' First Amendment rights under the Constitution, because defendants' actions are designed to chill, suppress, and control speech, reporting, and religious activities that they do not like. It's simply that arbitrary. Defendants' actions do not serve any governmental interest, much less a significant or compelling governmental interest. And defendants' actions are not narrowly tailored. So these words are technical terms, legal speech, legalese, compelling governmental interest, and significant governmental interest means our First Amendment rights are the highest form of constitutional rights that we have, and they deserve and they are required to receive strict scrutiny, which means any law or any action by the federal government will be struck down unless there is a significant or compelling governmental interest and the actions are narrowly tailored to that specific compelling governmental interest. And defendants have not shown that governmental interest in doing what they're doing in and around the Chicagoland area in the Northern District of Illinois. Plaintiffs and class members exercise their right to speak, assemble, petition, gather news, and freely practice their religious beliefs is being chilled due to the well-founded fear that they will be brutalized by federal agents for no reason other than engaging in protected activity on the streets and sidewalks of Broadview. Defendants' ongoing conduct in violation of plaintiffs' constitutional rights and liberties has caused and is causing irreparable harm, and therefore injunction is sought. And then there's the Freedom Religious Restoration Act that they're violating. Defendants' policies and patterns of targeting Reverend Black and other similarly situated religious exercise subclass members with violence substantially burdens their exercise of religion. Again, no compelling governmental interest exists for this type of violence. Fourth Amendment violations, in a manner described above, defendants violated and are violating plaintiffs' rights to be free from unreasonable seizures, specifically arrests without probable cause and excessive force under the Fourth Amendment. Remember, in the California and Nevada cases, the standard was reasonable suspicion because the basis for Donald Trump's going there was his immigration executive orders and the laws 12406 that allowed the deployment of federalizing the National Guard. Here, it is going, the plaintiffs are attacking and have filed this complaint and successfully gotten a TRO against all federal agents that are violating the First Amendment, Fourth Amendment, and religious rights of all citizens, and essentially name plaintiffs and the class of plaintiffs. So it's important to know the distinction between the two cases, because there are many legal arguments that, however attenuated, like my levying war argument, or however acute and present, like the violation of the First and Fourth Amendments that are cited in this complaint, there are many arguments to be made against what Donald Trump is doing. Going back to the complaint, defendant and federal agents discussed in this complaint are operating pursuant to an official federal policy, NSPM 7. It's not written there, but I'm reminding you what that policy is. Approved by responsible federal agency heads with final policymaking authority, of targeting plaintiffs and class members with unjustified violence and or arresting them without probable cause to believe that they committed a federal crime. Defendants intentionally applied physical force, including the use of projectiles and chemical weapons, on plaintiffs and class members. They also restricted plaintiffs and class members' freedom of movement through a show of authority. The force defendants used was unreasonable. The defendants have also arrested plaintiffs, held, and others similarly situated without probable cause, and solely suppress and chill and retaliate against the exercise of First Amendment rights. Defendants are prohibited by the Fourth Amendment from making preemptive arrests. Then there's a violation of the Administrative Procedures Act. Federal regulation provides that non-deadly force may be used only when a designated immigration officer has reasonable grounds to believe that such a force is necessary. And the facts show here that that force is not necessary. They will use minimum non-deadly force that's necessary. So the Administrative Procedures Act and regulations are in nature de-escalatory. Deadly force in any use of force that is likely to cause death or physical injury is that deadly force may be used only when designated immigration officer has reasonable ground to believe that such force is necessary to protect that immigration officer or other persons from imminent danger of death or serious physical injury. So there's the necessity of that imminence there. And based on as a proximate result of defendants' APA violations, plaintiff and class members are suffering and will continue to suffer from significant deprivation of their liberty in violation of the statute. Then there's declaration of rights, and then there's conspiracy, saying that the defendants acting in concert with other co-conspirators, known and unknown, reached an agreement among themselves to deprive plaintiffs and class members of their constitutional rights as described above. In doing so, co-conspirators conspired to accomplish an unlawful purpose by unlawful means. In addition, these co-conspirators agreed among themselves to protect one another from liability by depriving plaintiffs and class members of their rights. And in furtherance of their conspiracy, each of these co-conspirators committed overt acts that were otherwise willful participation in joint activity. So essentially claiming that this is an illegal conspiracy by the federal government and known and unknown agents to deprive American citizens and these citizens of our fundamental rights under the Bill of Rights. And it's a violation of the First Amendment, use of excessive and retaliatory force without probable cause to enjoin that activity, prohibiting defendants from dispersing, arresting, or threatening arrest, issuing a dispersal order required a public place that they lawfully have a right to be, unless dispersal is justified by the commanding officer's finding of a serious threat to public safety. There's a limitation on using riot control weapons, firing large riot control weapons, firing projectile riot control weapons, using force, unless there is a threat, and there is no threat. There is an enjoinment specifically included but not limited to pepper balls, paintballs, soft nose rounds at the head, neck, groin, torso, or other sensitive areas of any persons, or striking any person with a vehicle unless the person poses an immediate threat to serious bodily harm to a law enforcement officer or another person. So it is de-escalatory, because the person who is attacking you has to pose you an imminent bodily harm and serious harm or death for you to be able to retaliate with less lethal or non-lethal weapons like rubber bullets and tear gas and weapons of that sort. And here you have somebody from this third floor, roof of the second floor, shooting down at protesters, and you have ICE agents with pepper sprays clogging up the air duct of protesters wearing frog caricatures, balloons, or whatever you call them. And that's unreasonable, because the frog is not even crossing the blue line and going where they're not supposed to go. They're on public property. Using riot control weapon without giving at least 2 separate warnings in a manner and at a sound level that can be heard by the targeted individuals. And asking for an injunction stopping the government from using these tactics in the Northern District of Illinois. With that said, the plaintiffs say, please give us this and whatever other relief that you may give us. And the court does say that federal agents, defendants, except for Donald Trump, are to be referred to as federal agents, are temporarily enjoined in this judicial district, which is the Northern District of Illinois for the Eastern Division. So the Northern District of Illinois, as the court has said, dispersing, arresting, threatening to arrest, or using physical force against any person whom they know or reasonably should know is a journalist, unless the defendants have probable cause to believe that the individual has committed a crime. Defendants may order journalists to change location to avoid disrupting law enforcement. Issuing a crowd dispersal order requiring any person to leave a public place that they lawfully have a right to be, unless dispersal is justified by exigent circumstances as defined by the Department of Homeland Security use of force policy. So here there's a guardrail that you go back to, which is the Homeland Security use of force policy. Remember, however, that they can change that policy at any time. This order is only for the next 14 days, and they can change the Homeland policy at any time that they want. So it's a moving target. For purposes of this order, a crowd dispersal order is a lawful command given by a federal agent for all persons to leave a designated area when 3 or more persons are committing acts of disorderly conduct that is likely to cause substantial harm in the immediate vicinity. Balloon animals is not immediate harm. Peaceful protesting and walking down the streets is not immediate harm. It's not even close because you're not even being targeted. Then this court order limits the use of riot control weapons on members of the press, protesters, or religious practitioners who are not posing an immediate threat to the safety of law enforcement officers. Again, go back to that image, the video taken, and this is greatly important, and one of the best ways to protest is to videotape when you see what is happening. Timestamp it if it is possible. Put it on your social media account. The social media account, putting it there, timestamps it, and then when there are others who are also posting that same account from different angles, it sort of verifies it. So keep posting those videos, and we know that they were shot from the second story. I initially thought that somebody shot him at point blank range because it looked like there was a person right next to him when this pastor was getting shot, this priest was getting shot. But no, the shot came from the roof. And it posed no threat whatsoever what the religious practitioner was saying in that case. Using riot control weapons at identified targets if it is reasonably foreseeable that doing so could result in injury to the press, protesters, or practitioners who are not posing an immediate threat to the safety of the law enforcement officer or others, unless such force is necessary. And again, same thing applies for firing of the gas canisters, for firing of the compressed air launchers, for using force such as pulling and shoving people to the ground, using riot control weapons, seizing or arresting non-violent protesters who is not resisting a lawful crowd dispersal order, journalists, defendants are not, then it says the defendants shall not be held liable for unintentional violations of this order in the case of an individual who does not wear a press pass or a badge or other official credentials. So giving an exception to where there may be some gray area. But there's also a clear order here that it is further ordered that all federal agents, excepting those who do not wear a uniform or other distinguishing clothing or equipment in the regular performance of their official duties or are engaged in undercover operations in the regular performance of their official duties, have visible identification, something that federal agents have not had all throughout the country wherever they have gone, whether that be Los Angeles, Washington, Portland, or Chicago, or Memphis, or New Orleans. Visible identification for which a unique, recognizable alphanumeric identifier sequence will suffice, affixed to their uniforms or helmets and prominently displayed, including when wearing riot gear. Federal agents widely disseminate notice of this order to provide copies of this order and any individual scheduled to work at the Broadview facility as soon as possible, no later than October 10th. It is further ordered that defendants shall issue a guidance to officers and agents to implement this order. And this goes for 14 days. And I've gone on for 40 minutes. Thank you so much for being here. Remember to like, share, and subscribe. And remember that this particular order and this particular lawsuit and the way that it has been brought is very different from how the argument has been made in Oregon and California, which is about the National Guard. Here it is directly about the federal agents, the regime itself, the DHS, the Department of Homeland Security, Christine Noem, the federal agencies that are involved. So in a way, it's sort of preempting the Guard from even being deployed because it is enjoining these federal officers from doing these things to begin with. And we'll see if that stops the National Guard from being there, whether there's an appeal. Of course, there's going to be an appeal, and there may be a sort of a stay. I don't know how that's going to play out, but I think that the complaint here is strong enough and provided as well instances of this same conduct happening in the other places like Washington and Portland and Los Angeles. And so it provides a frame of reference for the Federal Circuit Court, the appellate court, to think twice before putting a stay on this enjoinment, on this temporary restraining order. And I hope that they don't, because it's only 14 days. And then this disposition will move forward. But whether this court order will actually stop the federal agencies from doing what they're doing and give Donald Trump pause to not have the National Guard present and withdraw the National Guard because their use has been frustrated, because that exigency does not exist, and the federal agents is self-evident that they're capable of using overwhelming force against protesters, where protesters are definitely the ones who are in the defense side, are definitely the underlings here, the underdog. So, this is a ongoing thing. We're going to see what happens with the appeal, and I'll go and talk about it when we hear about it. Now, I'm going to take off and also let you go. Thank you so much for being here, and I'll talk to you soon.